Good morning, everyone. I want to welcome everyone to the June 24th, 2026 meeting of the State Ethics Commission. Going to go ahead and look at the commissioners and ask if you've had time to review the agenda at all. Looks like we have 9 items that are on the agenda. First, I'm going to ask the staff whether they have any changes to the agenda.
Yes, under preliminary hearings, position B, that's been removed, that'll be continued till September, likely consent.
Okay. Do we still have items A and C for preliminary hearings?
Yes, we do.
In terms of consent orders, the only one that I marked with a question on, and I believe I know now, is one of Mr. Baywall's cases in the matter of Roderick Gay. Do we have signed consent order in that one now?
Yes, we do.
Okay. The only other change that I will note for the agenda will be that we are going to add an item number 9, which will be executive session to discuss personnel matters, and that will then renumber adjournment to item 10. Are there any other questions or comments with respect to today's agenda, commissioners? All right, hearing none, I'll go ahead and move to adopt the agenda as amended. Do I have a second?
Second.
Got a motion and a second. Any questions, comments? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, the agenda's adopted. We're going to go ahead and move now to item number 2 on the agenda, review and approval of the March 30, 2026 commission meeting minutes. Have all the commissioners had an opportunity to review those minutes? All right. Are there any changes to the minutes as they've been presented? Go ahead and call the question. All in favor, or excuse me, I'll go ahead and make a motion to adopt the meetings of the commission meeting for March 30 of 2026. Do I have a second?
Second.
All right. We got a motion and a second. All in favor of adopting the minutes as presented, say aye. Aye. Any opposed? All right, those will be adopted. Next, it looks like we're going to move to item number 3 on the agenda. These are the preliminary hearings. Mr. Knittel, it looks like both of these hearings are yours. Is that right?
That's correct.
All right, we'll start with item A for preliminary hearings. It's case number 26-0020-C in the matter of Lance Robertson. Do we have anyone here today on behalf of Lance Robertson?
We do not, then.
Okay. You can go ahead and proceed, Mr. Knittel.
All right, thank you. I believe you have the case summary in your packet. This case, this is one of we haven't done a lot of these recently, but we now have confidence in our new system. This is a case where it's a lobbyist, which is a little bit different than what we normally see. In this particular matter, Mr. Robinson, as it states here, he registered in January to be a lobbyist. He has 2 clients, the Natson Hotel Group and the Sons of Atlanta Vietnam Veterans, Atlanta chapter. And we initiated a complaint in late April of this year. We sent notices to his address of record and emailed to him as well. He did contact me, and I spoke with him some weeks ago. We discussed the case, but really didn't have any further discussion after that. I did send him a proposed consent, but based upon it not being returned, I guess he did not accept that consent, and so this is where we are today. But essentially, his violations are failures to file 3 reports, the January, February, March lobbyist reports. As the commission knows, reports are due every 5th of the month, so it's a monthly reporting scheme now. And so the statute that we're looking at is under 21-573. And actually, it's much simpler now in 2026 than what it was previously. Everybody simply supposed to file on the 5th of every month for the previous month, your lobbyist report. And you need to file whether or not you had any expenditures. So it could be a 0 report, it may be expenditures. And here I'm showing he did, after I spoke with him, he did go ahead and file those missing reports. But they were filed well after the complaint went out. May 28th is when he filed these reports. And typically, I wouldn't have a whole lot more to present on a case like this because it's pretty simple. Either you filed them or you didn't. But in this particular case, In my discussions with the respondent, he had indicated, previously within our office, we tried to get him to file these reports and also resolve the late fee issues. He indicated to our office that he had a medical issue that was preventing him from filing reports that, and I'm paraphrasing, but essentially he was homebound. And so these pictures I'm showing you are when he was claiming that he was unable to file reports and would have been homebound. This is a January 26th photo where he is presenting some issue in front of the Fulton County Commissioners meeting. And this is from his own Instagram. Here we have February 20th, legislative day at the Georgia Senate. He's out at the Senate doing all different things. He's there for Natson Hotel Group. Again, on February 20th, he's at the Consulate General of India. And the dates are circled, just these are things that he's posted on his own Instagram. And then April 18th, there's an event for Natson Hotel Group, again, related to Earth Day event where they're planting trees. Again, April 20th, he's again speaking at an Atlanta City Council meeting. And so the reason I showed those was just, I understand what his position was, that what he told me, but what I discovered, I think, was something different. I just wanted to make the commissioners aware of that. And so there are reasonable grounds to believe that he violated 21-573, and he did so 3 times for failure to file those reports.
Mr. Knittel, is he aware that you have these photos?
I'm not sure if he is aware or not because our discussion was brief when I talked with him on the phone. We didn't really talk about those.
Appropriate for you to let him know that.
I can let him know that, yes. But if he would have come here today, he would have those, and I'd be glad to talk with him, so. And he was aware of the meeting, sorry.
Okay. We don't get a lot of, preliminary hearings when it comes to these lobbyist issues. So I sort of did a deeper dive into this law, more so than preliminary hearings for failure to file, CCDRs and things of that nature. So, and I see the way that you've set this up, and I want to talk a little bit more about sort of what we can do when we have these types of violations, when it comes to lobbying. So, if you look at, OCGA 21-573, and that's where we've got, the disclosure reports, right?
Yes,
All right, and then you go to 21-5-6, and you see there that it says, civil penalty, cannot be assessed without it going to, under the Administrative Procedures Act and over to OSA. The only thing that I want to point out to this is that I'm going to send one more statute, this 21-572, is, it says, in addition to other penalties, provided in this article, the commission may by order deny, suspend, or revoke for a period not to exceed 1 year the registration of a lobbyist if it finds that the lobbyist, and then number 3 says, has failed to comply with the reporting requirements of this article. So I guess I'm asking you for your opinion as to whether we take a separate vote, okay? And whether we, as sitting here today, without having to go under the APA over to OSA, that we can go ahead and vote that we order, deny, or suspend or revoke one of the, a lobbyist registration for that period of time. I mean, we don't have to go to OSA for that, do we?
no, that is something that is entirely within the commission's authority and is not reviewed through administrative judge.
All right. So then I get concerned to some degree that someone like this individual, may not get notice. That's something that we can do, here today. But I'm looking at the complaint that was filed, and the complaint specifically references in the prayer, under subsection B, it says that it makes reference to 21-5-6B14 and also OCGA 21-5-72. So he's on notice that that we could actually take these actions today. Is there any disagreement over that?
I completely agree with the chair.
All right, so what we could do then is find reasonable cause to believe that 21-5-73 has been violated 3 times as reflected here, and then we could take a separate vote to suspend this gentleman's registration for, I guess, is it 1 year from today?
It's up to 12 months, yes, sir.
So that it would go past that one, I guess, the end of the year rule.
Correct.
We could actually extend it into next year.
Yes.
Okay, and
Yes.
there's no problem with doing that,
No.
considering what we do, with the lobbyist names at the end of the year? I'm going to let Commissioner Thompson speak on that because I think he's familiar with
He's
that.
familiar with it.
So the only issue I would bring up, or question I would bring up is, I know it says up to a year, but I don't know that we need to suspend or revoke it for 12 months just to the end of the year and then not allow them to re-register until such time they become compliant with past reports, because there's another provision in the law that says if you don't have your reports filed both for, I see Mr. Kuzak, Commissioner Kuzak, he's gonna challenge me on this, that if you don't have certain reports filed, you can't register, right?
That's
So-
correct, and that's
so
what's in place right
I
now.
would say we could do the 12, but I don't know I don't even know how they just don't allow him to register until he becomes compliant. Maybe that's something to think about. Is there also a way, because I know with lobbyist badges, you're then able to apply through GBA and get a certain access because you're properly registered with the State Ethics Commission? Is that not true?
Yes?
Okay. Is there a way we could have that stopped? Says or at least notified GBA
We can certainly do that, yes.
that he's no longer properly, and that way when he tries to get in,
Yes. Those are all things we can do and will do with approval by the
Does
commissioners.
that require commission action, or is that action that can be, taken just by the staff?
So I think the order to suspend or denies registration requires commission action.
Okay.
With that, we can then do those other actions where we, turn off the badge and contact whoever we need to prevent that.
Just real quick so that I don't forget
Yeah.
this thought. Again, to sort of satisfy something I think you may have been talking about, would it be better to say that we're going to suspend his registration until such time as he complies with what he hasn't done so far, or up to a year?
Yeah, I think that's fair, but.
Is he compliant though? Because he filed the missing reports.
Excuse me, Commissioner, I didn't mean
No,
to
no, no.
interrupt you.
He filed those on May 28th, right?
He's not compliant because he also has refused to pay any late fees.
Okay, so he hasn't
And-
paid the late
and
fees as well.
as the commissioners know, when, especially during during session times, the late fees get rather exorbitant quickly. And he's, that's a discussion to have with him, but he has not paid even the basic late fee. He just not taking any action on it, so.
For the record, if you don't mind, if you'll indulge me, explain how they become, just so people know, how they become absorbent, whatever fancy word you use. And what notice, if any, because I know we've had this conversation several times about we can't increase CCDR late fees unless they get the law, I believe the law says, notice the same way they filed their reports, right? So does that apply, just for everyone, does that apply for lobbyist reports as well? Or does it automatically, escalate?
It's different than the CCDRs. I believe our statute is silent as to notice with lobbyists, and if it specifically has it in when related to campaign finance. So therefore, I think the notice requirement is there for campaign finance reports. Lobbyist reports, it's not there. It simply says it shall be increased. So I think by virtue of being a lobbyist, you should be aware of what your rules and regulations are. There's not an additional notice provision that's required before
Like
they.
the CCDR. So to
Correct.
that point, what late fees are you assessing to this individual? Since he has filed, to Commissioner Kuzak's point, he has filed, but he was late. What late fees would he have to file, and what kind of notice, or, what's he gonna have to, how much is he gonna have to pay? Let's just say that. You don't have to figure it out, but will it be escalated, I guess is my point.
There will be escalation. I guess I can't give you a
It's all right.
specific number, but
No, I understand
I
that.
would anticipate some escalation of that,
And I
yes.
think what the chair and I are trying to do is, I think we're trying to establish a precedent here so that lobbyists know that the State Ethics Commission is no longer gonna sit on their laurels and not do anything about lobbyists. I learned that word last night. So anyway, and that we're going to actively, monitor these things because the new system is not as bad as I thought.
Thank you, and that's kind of what I wanted to mention, just for some history for, if there's some newer commissioners here. Our previous system, we had confidence issues as to whether we could confidently believe that it was letting lobbyists report when they needed to, if the reports are accurate, things of that nature. Our new system does not have that issue. It works beautifully. And so, anyhow, our new system works very well, and we do have confidence in it. And that's why we can start looking at some of these lobbyists that simply, in lack of a better word, they get notices, we call them, we send them emails from the new system. They're getting notices that these late fees exist, and they simply ignore us. And we have limited tools, and this is one of those.
And one last point. So did you do a system-wide, for the record, of people who haven't filed? Or how were these individuals identified? Just,
Yes, we did a system audit essentially. And we worked, look, because it's a new system, we recognized they were not used to essentially some of this being enforced because we didn't feel confident we could do that based upon our problems we had with our prior filing system. But now, we do have the ability to do that, and we've reached out to lobbyists and say, hey, we're gonna be moving towards this. We've given a little grace in the beginning, but this needs to change, and that's how we're changing it. So
It
we
is
do
not-
contact.
is it not true the system is so aggressive that if somebody misses after the 5th day, that they start getting 20 emails a day? Is that not true?
Okay. I'll also say, I spoke at the Georgia Public Lobbyists Association meeting, I think 2 weeks ago, and I announced we are moving forward on a number of lobbyist cases, and the reception was actually excitement. Their attitude is if we're doing things the right way and someone's not, we want to see y'all do something about it. So they were pretty happy with that information. And that we have communicated with them that this is going to be something we now have the ability to, for the first time in years, to do more aggressively. Or I should say the commission has the ability to do.
Stay off your phone, too. You have something more important to be doing?
So I
Maybe,
guess-
maybe.
I've got two questions I just want to make sure of.
Yes, sir.
All right. How often do we get a third-party complaint about a lobbyist?
It's infrequent.
We've had several, though, that we were not able to move forward.
Oh, yes, yes, in the past,
Because,
yes.
I mean, just since I've been here, we've had several of them, and Commissioner Kuzik's nodding his head because we tried to bring them forward, but then whatever, and we've had several, but not that many.
Right, compared to our other cases, I guess is what I'm saying.
And is it because the third party didn't actually end up wanting to pursue it?
I think it's, I
Yeah,
don't know if you wanna,
Well, the evidence was hard to
Yeah,
get. I think.
the evidence is difficult to get.
Can I have one at a time, Mr. Green?
Okay. The evidence can be difficult to gather, and the people that typically would have it aren't always willing to put their name on an affidavit and a piece of paper. So,
Okay.
informally, we've had a lot of complaints. Formally, it's pretty rare.
Okay. Last question, I think. So I just want to make sure from y'all's perspective, is it workable if we were to make the type of motion that we're talking about, where it would be a 1-year suspension, I guess, of the lobbying registration, or to satisfaction of whatever's outstanding at this point, the current violations? Is that
yes.
something like that?
Something like
Did
that.
that make any sense?
It did, I understand, because the provision that allows you to suspend and also gives them an opportunity to remedy that.
So we
by-
would need to refer to it as suspension as opposed to any type of revocation.
I think that's probably more
Is it the
appropriate. It's basically the same, but I think suspension is more accurate because they do have the opportunity to remedy the issue.
Well, is it not true if we revoke something, then they would have to go back through the process of registering? Suspension just holds it, where revocation, whatever fancy word he used, was, you'd have to redo it, right?
So is this a conditional suspension where if you meet these conditions, you have then sort of purged yourself of the issues that you have? So we're gonna say, is that what I'm hearing is, once you pay these fines, because you filed the reports now, you are, I guess, reinstated as a lobbyist? Like, are we gonna require them to go through the registration again?
I think that's gonna depend on the motion you make.
Right.
Yeah, I think it's.
Yeah.
Okay.
That's why I
And
was
it may be
asking.
Yeah.
dependent on the individual case too, depending
Okay.
on what's going on, I suppose.
So in that instance, if we want them to go through the registration process again, it would be a revocation.
Yep. And they would, in any event, Mr. Chairman, lobbyists need to renew the registration each year. So it's almost like a de facto, you have to re-register, kinda, because they have to renew the registration if they're not able to because they have to. Yes, sir.
My last thing. Is there a way in the system that you can make sure that they don't try, because I know the system's electronic, that you don't approve when it comes through? I mean, is there a way that the system can flag that? Or is that gonna be an extra fee from, Peach Fuzz?
I believe we should be able to,
Okay.
to flag names, individual names, because that's probably how it would work. We spend our name.
If you make a conditional suspension and then the individual satisfies the conditions, how is it made known that the suspension is lifted? What would be the mechanism for, okay, you've done it, now the suspension's lifted?
I guess I would envision that as that's something that internally within the office, we would indicate how it was resolved, that they've paid those things, because that's all tracked in their file.
You would track it and then you would notify this individual, okay, you've satisfied the
Yes.
conditions, and
Yep.
there would be a record of that?
Yeah, and there would be administrative notes to that effect, so it'd be well documented if that were to occur.
And you could always keep a list in the office.
Yeah,
you
I'm
know, of
hoping
those
there's not a whole
files.
lot of these, honestly,
Right,
but,
right,
yeah,
right.
yeah.
Well,
so-
there may be
There may
more
be.
now.
Yes,
Okay,
so,
yep.
Well, so I'm in subsection B now, where it's saying application may be made to the commission for reinstatement. Such reinstatement shall be conducted in the same manner as required for an initial registration under this article, and shall be conditioned upon payment of the same registration fees applicable to an initial registration, and also any outstanding penalty fees. So is that the process that we're gonna go through to be reinstated, or I'm thinking we can just make a motion to condition it, or do we wanna, I don't know. I know we're sort of building the plane while flying, but
Again, I guess the way that I read B would be, what we're talking about would just be an all-out revocation.
okay.
And then we would, we would do it for a year, but if they satisfy all the late fees or whatever else they have out there, then, they would get it back, and then.
yes.
I guess if it's past the end of the calendar year. No, that would still require them to reapply, right? Or re-register.
Well, and I think the application has to come before this body, unless we delegate it. Because the application's made to the commission for reinstatement.
I think that's commission staff.
Yeah.
Okay, I'm good with that.
Yeah.
I just want to make sure.
Yeah,
Yeah.
that's the way I would interpret that.
Okay, I'm good with that.
Yeah. All right. Any other questions, comments? Mr. Canetto, you have anything else on this one?
No, I think we've covered it.
I'll make a motion that reasonable grounds exist, that the respondent failed to file the 2026 January lobbyist report in violation of OCGA. Really? 21-5-73. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that motion passes. I'll make a motion that reasonable grounds exist, that the respondent failed to file the 2026 February lobbyist report in violation of OCGA 21-5-73. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion passes. Make a motion that the respondent failed to file the 2026 March lobbyist report in violation of OCGA 21-5-73. Do I have a second? Second. Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion passes.
Here we go.
I make a motion that we revoke the respondent's lobbyist registration pursuant to 21-5-72A3, to such degree that it be for 12 months or until he satisfies any outstanding violations. Got a motion, is there a second? Any discussion?
So,
Is it whichever comes first?
Yes. Was that not?
I'm
Okay,
not sure.
hey, if you've got it a better way, I'll withdraw my motion.
I don't.
so this means, just for clarification for me, this means filing the reports and paying whatever late fees the agency,
Assessors.
deems appropriate, right? Is that the motion?
Yeah, give me 1 second.
Yes.
Practical standpoint, I guess when the order is signed on this, will you send Mr. Robertson a copy of the order and let him know that his lobbyist registration has been suspended, so he is unable to lobby? And if he does so, I believe that's another violation because he'd be an unregistered lobbyist at that point.
That is correct, and yes, we would certainly do that. Like we do with the orders, we include something to that effect.
Okay, so you can actually violate again if he continues to lobby and he's unregistered, so,
Yes.
okay, thanks.
Well, now I'm thinking about this. If it is just revoked until he satisfies the requirements, isn't that sufficient? Because if you say either or, I guess we're saying in 12 months, it's no longer revoked despite that he hasn't paid, although I'm hearing also that you can't reinstate until you pay. That's a little circular.
If I may, I think, Commissioner, I think that what the suspension that, if this commission, if this body were to order that, what that assists with is middle of the year when we can't end of December, they have to renew, and if they still owe fees, they're not allowed to renew. This gets in place before that renewal time comes, so we can stop them from continuing lobbying without having paid late fees or filed reports.
Okay, and it's not an assurance that 12 months and a day, he's reinstated, because he still has to go through.
Correct.
Okay,
Presumably, right, he's not gonna be able to renew or register again until he fixes the issues he already has.
Okay.
Regardless.
What do y'all think about this?
I like it.
If this motion was made, if this would satisfy everyone's concerns, a motion to suspend the respondent's lobbyist registration pursuant to OCGA 21-5-72 for 1 year or until the time all pending violations under the act are satisfied. You're never gonna be able to read it.
I don't want me to read your thing. I want to read them all.
I'm talking about that
Yeah,
next.
yeah, I know. But my only concern is what Commissioner Kuzak brought up is this sentence, that the only way that it goes away is having to, I'm sorry. Well, it's up to you. Yeah, okay, sorry. My only concern is that the second sentence of B is saying that the suspension, the way I'm seeing it, as Commissioner Kuzak brought up, that his registration has to be done the same way as initially. Is that not true, Mr. Kuzak?
How about this? Sorry, I'm not answering for you, but motion to suspend the respondent's lobbyist registration pursuant to OCGA 21-5-72 for 1 year or until the time all pending violations under the act are satisfied and following re-registration with the commission.
Yes. So you're
Mr. Kuzak?
withdrawing your motion and then?
I am. I'm now making a motion to withdraw my original motion. Do I have a second?
second.
Got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? None. I'm now going to make a motion that commission suspend the respondent's lobbyist registration pursuant to OCGA 21-5-72 for 1 year or until the time all pending violations under the act are satisfied and following re-registration with the commission. Any second? Got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Thank goodness. All right. Before we leave this particular case, I also wanted to point out something in 21-5-72C. It says that any person failing to comply with or violating any of the provisions of this article shall be subject to a civil penalty not to exceed $2,000 per violation. I think when this goes over to OSA, that we need to make note of that, because again, we gave him notice about 21-5-72. So the way I read this is that he gets hit with that civil penalty there, and I think an argument can be made that he gets hit with a civil penalty under 21-5-6 as well. So that's just something, again, that's not a motion, but the way that I read these different, laws as applies to a lobbyist, I think that there's a separate civil penalty that can be added there.
Okay,
Just wanted to note that.
all right.
All right? Okay. We'll move next on the agenda to preliminary hearing C. It's case number 26-0044C in the matter of Tamiko Jones. Mr. Canettle?
Thank you. This will probably be happily for Vice Chair, one of the shortest presentations of PowerPoints. This lobbyist,
I'd be happy if there's no problem.
well, I know, but there's 5 commissioners I want to show. This lobbyist registered on February 2nd, 2026. She has 2 clients listed, Journey Foods and JAP Innovations. The complaint was initiated on May 15th. Notices were mailed to her address of record and emailed. She did respond via email about this case, and I likewise responded and have heard nothing from this person since. So that's the procedural history on this. But essentially, this lobbyist failed to file 2 reports, the 2026 March and 2026 April lobbyist reports. That's just the statute again. And this shows the missing reports from our system. And again, that's the entirety. She simply didn't file them. So there's reasonable grounds to believe that this respondent violated by failing to file both those reports, and I asked the commission to find that way.
Is there any issue with payment of fines as there was?
Thank you. Yes, she has not paid any fines. So I
She's
think
been
this.
asked- she's been requested to pay or directed to pay, and she has
Yes,
not paid.
and again, in our new system, we are sending, it generates to their email address of record, which they provide us. It sends an invoice for the fines, lets them know. It even tells them, report's coming up, your report's late. All those things happen. We have documentation of all that in our system, and it's been 0 response,
So it's the same as the previous one, except for she missed 2 instead of 3?
exactly the same. So this would be another case where I'd ask the commissioners to look at what was just proposed in the last case, as far as suspending or revoking.
She doesn't have a social media
I-
following like the previous one?
Haven't been able to speak to her, so, to know if she was ill or not.
All right, I'll make a motion that reasonable grounds exist to believe that the respondent failed to file the 2026 March lobbyist report in violation of OCGA Section 21-5-73. Do I have a second?
Second.
Got a motion and a second. Any discussion? Go ahead and call the question. All in favor say aye. Aye. Any opposed? Motion carries. I make a motion to find reasonable grounds to believe that the respondent failed to file the 2026 April lobbyist report in violation of OCGA Section 21-5-73. Do I have a second? Second. Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion passes. I make a motion to suspend the respondent's lobbyist registration pursuant to OCGA Section 21-5-72 for 1 year or until the time all pending violations under the act are satisfied and following re-registration with the commission. Do I have a second? Second. Got a motion and a second. Any discussion? All in favor say aye.
Aye.
Any opposed? Motion passes. Does that complete that preliminary hearing as well, Mr. Knittel?
It does, thank you.
When we have the next lobbyist issue, let's keep that language and put it on the screen as well, okay?
Yes. We will adopt that language.
Okay. That way we don't have to go through all of that. Okay, so we're now to item 4 on the agenda. It's the consent orders. We're going to vote on all of these under the Hicks rule at one time. Mr. Cusack, I think that you wanted to pull one out, is that right?
Let's see, if we could pull out in the matter 25-0072-C, in the matter of Jennifer Philippi, Councilmember Philippi is kind of my boss. But in my day job as Assistant City Attorney in Roswell, I represent her as a council member in the city, so I'm gonna recuse from that one from any
Okay.
consideration there.
We're going to ask Ms. Judd to go ahead and come up. Can you go ahead and come up and do that case? And then we'll vote on that separately, and then we'll go back to all the others. Does anyone else have any that they want to pull out individually? Any commissioners? Okay. This is, case number 25-0072-C in the matter of Jennifer, is it Philippi or Philippi?
Felipe is how I was pronouncing
Okay.
it, but it could be wrong. Philippi. Miss Philippi, she's very nice. I worked with her for pretty much over the last year. She's currently a council member, as Mr. Cusack mentioned, but she previously was the unsuccessful candidate for Fulton County Board of Commissioners District 2 during the 2024 primary election. She filed her DOI on May 17th of 2024, which was actually only 4 days prior to the primary election, which leads us to 5 different violations. This was a third-party complaint that our office received. One of those is that she had pre-DOI contributions and expenditures. She filed a CCDR, but she didn't file the DOI prior to the CCDR. She thought it was filed, and it hadn't been. So that's the reason for the violation of OCGA 21530G. And then she had 3 violations of OCGA 21534 C2A for missing the CCDRs after she lost the primary election. And then 1 violation of 21534M for failing to timely file a final report and termination statement after she lost the primary election. So her penalty was $1,500, 4 late fees, and a $1,000 civil penalty. And like I mentioned, she was extremely cooperative. We were able to get her banking records and get her in compliance.
Any questions? I move that we adopt the consent order in case number 25-0072-C in the matter of Jennifer Philippi. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Motion carries. Okay, Mr. Knittel, we'll come back then. The first one's going to be case number 26-0021C in the matter of Brandy Lee Blue.
Thank you. Yes, so this case, this is a lobbyist case. Ms. Blue registered as a lobbyist on January 8th, 2026. She had 2 violations in total, failure to file 2026 March report and also the 2026 April report. Total penalty was $500, which consisted of $250 in civil penalties and 2 late fees of $125 each, and to have her registration terminated. Some information about this is very similar to the next one. This respondent was working as a fellow with the ACLU of Georgia and was asked as part of her fellowship to lobby on behalf of them. She was very cooperative once she received the notice. Actually, no, it took her a while to receive the notice, and I'll explain why that happened. She was a fellow with the ACLU for a couple months. And after that, she didn't have access to the email, which was registered. So she didn't even know this was happening. But we were able to reach her, and I spoke with her. She didn't realize that her lobbyist registration didn't automatically terminate when her fellowship terminated. I think she was in a situation much like the next person. where she just maybe was outside of her depth, and she was there for a very brief period of time, and she resolved the matter rather quickly. So that was that result.
Case number 26-0013C in the matter of Kendrick Holder.
Mr. Holder, likewise, was also a fellow with the ACLU of Georgia. He registered in January 13th, 2026. He also had 2 violations. He had a failure to file 2026 March lobbyist report, and he also had a late filed 2026 lobbyist report. The penalty for him was, I treated him in a similar manner because he had similar fact pattern. $500, which consisted of $250 in civil penalties and 2 late fees of $125 each, and to have his registration terminated. Likewise, he did not, yes, Vice Chair.
At the
Go
appropriate
ahead.
time, I have a question.
No, go ahead. If we're on one of these, then
Okay.
I just,
So this question goes for the last one too. Can you just, for my edification, explain the progression of the late fees for the lobbyist reports? And are they being applied to these cases we're talking about? Or are these individuals are being given some consideration because they're entering a consent order? So what's the late fee progression?
Yes. So, yes, both these individuals were given consideration for resolving their cases quickly. Also, I think they had some mitigating circumstances with how, probably different than what a typical lobbyist would be. They were there for, yes, sir.
Okay. So it's my understanding from the past that we as an agency, and everybody can correct me, that late fees are statutory, right? So we don't have the ability to modify what a late fee is. Correct me if I'm wrong, because that has to do
But we
with
do have the
your
ability to
lawyer
waive
stuff.
late fees for various reasons.
Say
There
what?
has to be.
We do have the ability, if they submit a waiver, to review
If
that.
they have a waiver,
there's a hardship
Yeah.
that applies as well, right?
Yes.
if they have a waiver, was a waiver submitted?
A written waiver, I believe Ms. Blue sent one, but I spoke with both individuals and I tried to understand their circumstance. And so I did exercise discretion on this because of the
Do we have that
circumstance.
authority to exercise discretion? And I'm just asking that because I think what we're trying to do here is we're trying to, again, set a precedent and let people know how we're gonna treat all cases the same way. And that's the only reason why I'm asking.
a fair
I don't
question.
disagree with this.
I think, again, hey, I'm a black letter guy. If we set it as a number, then that's fine. But I think we're gonna come across situations like the one presented in this first case. I mean, was there a progression of her late fees because of the whole communication issue? The fact that, she didn't have that email anymore, and so she didn't even know what was happening. She wasn't, we had no way of contacting her.
And I
Where's the
want to,
burden on her to stay in touch with the commission if she's got a lobbyist registration?
I mean, ultimately, yes.
Okay.
I think that's the absolute correct answer. Again, I think there's some mitigating circumstances in this, what I described, but ultimately, she's responsible for filing. She needs to file and stay in contact. I
But my
understand.
point is that, and I apologize for not bringing this up on the last case, but we're talking about 2 different cases that are getting the same fees. Are they the same circumstances because she didn't have access to her email? And I get that, that's a mitigating circumstance, I heard that on Law and Order. But the second one is not the same circumstance, is my understanding, because they did have access to their email.
Are you referring to the
Which-
second consent or the one we had to prelim? Because the
No,
second,
the 2 consents.
actually, no, Mr. Holder also, they
Oh,
both.
he didn't have access
No,
to his
they're
email.
exactly the same circumstance. That's what I didn't quite get to. But yes, exactly the same circumstance. Their email was like an ACLU.org or something, and so somebody there received it, they weren't receiving it, and nobody there ever communicated that to them.
What was, they were doing a fellowship or something?
Yes, yes.
Okay.
And it was approximately 2 months, their fellowship, so.
Right. Okay.
In any event, so Mr. Holder really is exactly the same, and so the same result is what I offered on the consent, and
That's all yours?
yes.
All right. Mr. Baywall, looks like, you've got about 6 or 7, right?
I have a few, sir.
All right. Good morning.
Good morning. Position C, David Musio, case number 24-0123. This was a third-party complaint that our office received. It alleged that Mr. Musio was engaged in unregistered lobbying. Mr. Musio, he also goes by the name Cole Musio. He's an officer and director of two organizations, Frontline Policy Council and Frontline Policy Action. And Frontline Policy Council is a nonprofit, a C3. Frontline Policy Action is a C4. Both entities engage in lobbying, and that's apparent. They're very vocal on social media. They're vocal at the Capitol. They are lobbying agencies. The primary evidence that accompanied the complaint was most of Frontline Policy Council and Frontline Policy Action's social media, meaning they would make posts updating on the progress of certain laws. SB 54 just passed. We've been working hard on this. There would be a lot of, pictures with, some with David Musio or Cole Musio appearing alongside a senator or a state rep, other members of both organizations. But the communications on the social media, I wouldn't necessarily call them lobbying, but they're promoting their brand, saying this is the lobbying work that we're doing. These are the contacts we're making. And that was the, there wasn't a specific, they engage in unregistered lobbying X amount of times or on these times, but it was more, they're promoting themselves as a lobbyist group. He's appearing at the Capitol and he's an unregistered lobbyist. And that was basically the starting point of the complaint. The complaint listed approximately 15 state reps and senators that might have information regarding lobbying activity. Starting point with my investigation was trying to attempt to contact those representatives and senators. Okay. And I set up phone interviews with a lot of those members, and the interviews the information that they were providing was probably more beneficial to Mr. Musio. They differed in degree, but most people were saying Cole Musio, he used to lobby at the Capitol. He's now running these two organizations. He will appear occasionally, but they have a registered lobbyist, Taylor Hawkins, who's doing the bulk of their lobbying. So I did attempt to make those contacts initially, and that was probably negative evidence in the case. It was evidence actually that was bolstering Mr. Musio's claim, which was, I'm not a lobbyist. I'm not paid to lobby. I'm paid to run both of these organizations. There were a number, maybe 5 or 6 witnesses I would call on the opposing side, other lobbyists, registered lobbyists on the other side of the aisle as Frontline. And I set up interviews with people who were willing to talk. There were maybe 3 or 4 willing to talk. Most of what they were providing was, Cole's at the Capitol every day. There's other members that are at the Capitol every day. They're lobbying. A lot of these allegations go back to 23 and 24. And so in calendar years 25 and 26, when you're trying to get specific information, it's very difficult. People don't, and when you're talking about lobbying, it is a very fact-specific analysis. So the second batch of witnesses on the opposing side of Frontline, they were giving generic information. Yeah, they were there, they were at the Capitol. We can see them hanging out with different representatives and senators, but it wasn't, in my opinion, they're promoting House Bill 54, they're, opposing a particular bill, but I did talk to those witnesses. I then shifted gears. I did a lot of investigation, just combing through. The Senate is better than the House, but meeting minutes, because every standing committee, not all of them, but some of them will keep published meeting minutes. and combed through a lot of meeting minutes to find who's appearing in committee from Frontline on these bills, who's testifying in support or opposition. And I would say the evidence that I gathered from that was that Taylor Hawkins, during this period, the registered lobbyist for Frontline Policy Council, he was doing the bulk of the lobbying work. I also reviewed Old School, the General Assembly. They have video recordings of all of these committee meetings. And there's over, 40 committees in both chambers. And I tried to at least I tried to look at the legislation that Frontline Policy pushes, the different areas. They're not pushing, banking or finance regulations, so I didn't have to go through every committee, but I tried to find committees that I think, bills that they might be interested in. I tried targeting those committees, and Old School, turning on the video and just watching. I did a lot of watching just to see, I knew what Taylor Hawkins looked like. I knew what Cole Musio looked like. I knew what other members of Frontline Policy looked like. And it was just Old School trying to find, can I see these individuals, testifying before committee? Which there was an extensive investigation into that. And especially after talking to all the witnesses and not having good detail, not having good memory, I'm trying to find things that are concrete to say, yes, this person's engaged in lobbying, or no, this person's not engaged in lobbying. If people contact me about a case, I will always get back to them if they want to add input, legal, factual. If they want to point me in the right direction, I will always take it. There were 2 individuals who contacted me anonymously. They provided PowerPoints. They put work in on it, and 2 individuals, posed to Frontline that wanted me to get this information. I reviewed those packets. Initially, on our filing system, when you pulled the entity registration, so the lobbyists, they register individually, but they lobby on behalf of an entity. Originally, when I looked on our filing system, I saw the entity listed as Frontline Policy Council / Frontline Policy Action. And it was my belief that at all times relevant to this complaint, that both entities had a registered lobbyist authorized to lobby on their behalf. Also, at all times relevant to this complaint, Cole Musio was an officer and director of both organizations, and there's an officer carve-out that exempts officers and directors from registration under certain circumstances. And one of the elements to that is they have to have a registered lobbyist. So initially, I did not think I had a strong case against Cole Musio. I had, some evidence of him appearing at the Capitol. I had some evidence of social media postings, but not to the point where I was comfortable saying, I think this individual is compensated for the specific purposes of lobbying, and he needs to register. One of the anonymous sources brought this to my attention, and she brought it to me, he or she, I think she's a she, brought it to me early on, and I overlooked it. And the reason I overlooked it is because when I looked at the entity registration, I saw Frontline Policy Council and Frontline Policy Action together as the listed entity. And that was not the case. So what happened is in 23 and 24, in 23 there were 2 registered lobbyists for Frontline Policy Council only. And I went back and I pulled the old paper registrations to see who these particular lobbyists listed as the entity that they were authorized to lobby on behalf of, and it was Frontline Policy Council only. In 2024, there was just 1 registered lobbyist for Frontline Policy Council only, and that was Taylor Hawkins. So my analysis shifted because now we were in a scenario where I have evidence that Frontline Policy Action is engaged in lobbying, and they don't have a registered lobbyist with the commission. And because of that, it was my belief that Cole Musio, or David Musio, was no longer, he was no longer able to claim that he had protection from the officer or director carve-out. I identified 24 instances, and I filed a notice of additional allegations in this case, detailing 24 instances that I believed was either direct or indirect lobbying by Cole Musio or just generically Frontline Policy Action. I will just characterize most of the communications are emails, and the substance of the email might be a mass email that Cole Musio sends out. You know, Senate Bill 52 is going to be heard before committee. This is what it says. This is why we agree with it. This is why we don't agree with it. All of those emails had a link embedded that allowed the reader to click on the link. So it was a call to action link, so they could contact their representatives and let them know how they felt about specific legislation. So that type of material was the material that comprises these 24 instances. Some of it was direct email from Cole Musio. Some of it was social media postings on Facebook. Some were specific postings by Cole Musio. Some were just generic Frontline Policy Action postings. There was an email chain where Cole Musio was contacting a member of the executive branch, encouraging a position on a particular bill that was included in the 24 instances. And there was one instance where Cole Musio testified in front of committee supporting specific legislation, and that was on video. That was the investigation that occurred in this complaint. These were the 24 instances that I alleged were violations of the act. We have a consent agreement before the commission for the 24 violations of 21-5-71, and we have an agreed upon civil penalty of $7,500 for this matter.
Commissioner?
How did you come up with the $7,500 for 24 violations?
So I looked back through all of our consent orders, and I found one consent within the last decade involving a lobbyist complaint. The last name is Simons. I forget the first name. It was a 2014 complaint. We processed it in 2017. I looked at the facts and circumstances of that case. That complaint was resolved with a $15,000 penalty. I know.
And that was a pretty egregious case, if I remember correctly. Sort of ties to the Savannah area, too.
Okay.
Yeah.
That was the next point that I was going to make. I did look at the facts of that case, and I know there's adjustments for inflation. That was a 2017 resolution at $15,000. But to Mr. Cusack's point, comparing that fact pattern to this fact pattern, I felt we were far within that $15,000 amount to resolve this complaint. That was also, I think, a 3-year litigation where we had that case. And that was a case where, Mr. Musio, originally I thought he had some grounds because he was compensated as an officer and director on whether or not, there was some debate whether he needed to register, at least initially. In the Simons case, I don't think there was any debate. I think there were actual written contracts between two organizations where Mr. Simons was employed.
Thank you. Thank you.
Thank
You answered my question. Thank you.
Anything else on that one?
No.
Okay. I assume the next one's closely related?
It's different. The next one focuses on the independent committee side of
All right.
Position D, Frontline Policy Action, Inc., 25-0036. This was a third-party complaint.
I don't want to cut you off. The question that I have on this one and I'm sorry, I'm borrowing his computer.
That's your computer, someone.
Oh, I did, sorry. I saw a number on this one. Yeah, so failed to report contributions in the amount of $367,520.45. So I'm gonna ask the same question
Yes.
that Commissioner Thompson just asked. How do we get from that number down to, what is it, 10 or 15? 10.
There was a, wait. One more time.
Yeah, I'm looking at this consent order, and if you look at the bottom of the first page, it says, in this matter, respondent failed to report contributions in the amount of $367,520.45 during the 24 election cycle. And I see that this one is resolving civil penalty of 10,000.
I will get to that.
It's different?
Now, another thing I want to point out too,
No, I know, and I don't want to, I'm not saying to compare this to the prior case. That's not my point. My point is, how did we get from 367,000 down to 10,000?
because I have one provable violation.
Okay, what is that?
It was really one contribution that they didn't report. And the reason I was able to actually stretch it to 10,000 or an $11,000 max is because it should have been reported on a 2-day and a disclosure report. I have an $11,000 maximum to work with in this case.
So the disclosure report that dealt with this actually listed the expenditures, the IC was registered,
Correct.
listed the expenditures, but failed to disclose the contribution coming
Yes, sir.
in. Okay, so the disclosure report basically was filled out correctly minus the contribution.
Correct.
Okay, all right.
Okay.
I see what you're saying.
I'm sorry that I'm missing this, but why don't we have one that's already been signed with this same group, and I looked the same date, and it's got a different amount?
So, and I'm going to clarify that. So originally I filed a notice of allegations, and the amount that I listed was $367,000. And this was back in January. I don't recall specifically the method why I had that amount, but it's a pretty specific amount. I used that amount from the notice of additional allegations when I did the consent agreement. Consent agreement was signed, it was published. I was pulling everything together, just preparing my presentation today, and I saw that they had reported $380,000, a little over $380,000 in independent expenditures on the report. And so I contacted opposing counsel, and I made the amendment. So the original consent agreement has the amount $367,000. I ended up changing that just because I wanted to parallel the amount of independent expenditures that they had listed on their disclosure report, which was a little over $380,000. So it was more a technical error that was the purpose of the change. And I did.
They agreed to that, so this one that's signed by both already, the 380 is the one we're working off of.
Correct. And the amount is not necessarily, it doesn't have an impact on the end result of the case. But I wanted to parallel the reported independent expenditure amount that this group spent.
So that's to zero out the account to make sure that it was terminated correctly.
Correct.
Okay.
Well, not necessarily, they didn't have to zero out to terminate, but I guess my thought is if you have $380,000 in independent expenditures, you need to show $380,000 worth of contributions.
So did they actually terminate, or are they still reporting right now?
They terminated by operation of law at the end of
24?
24. We have an agency rule. It's similar to PACS. They automatically terminate at the end of the year. They don't have to zero out, and then they
But if they have an outstanding balance, they still have to report. Was there an outstanding balance?
yeah,
Probably-
there's an outstanding balance, but it's my understanding they don't have to zero out and terminate. They just re-register and
Wait,
carry
say
over
again?
that. If an at the end of the year, an independent committee, if they have funds on hand, they don't have to zero out to terminate, but they automatically terminate by operation of agency rule.
Why then, under the law, is there the supplemental reports for an independent expenditure committee?
That's if they re-register, but they don't have to re-register.
I don't know that I agree with that. I don't know that I agree with that.
Yeah, so you have to, you,
We're also
you,
getting sidetracked.
yeah, I know we're getting sidetracked, but I'm just, I'm curious
Oh,
as
we
to.
are getting sidetracked, but
Yeah,
I don't want statements out there that aren't right.
yeah. Cause like you have the supplementals on June 30th and December 31st of each year after, if you have that outstanding balance. So I thought with the 380,000 you're talking about, I thought it was matching up because that's what they needed to ultimately close out the account and not file anymore.
I think we have an agency rule that discusses,
I don't think the agency rule trumps the statute
Yeah,
that
the statute.
creates a supplemental filing requirement for independent committees.
well, I have been analyzing this, that the independent committee does not have to zero out, and they have to, if they decide to, they can re-register, but if they don't, I know the rule on supplemental reporting, but I don't,
Well, we should be glad that Mr. Evans was on the other side of this, because he should know it as well.
You should.
it is my understand,
I don't know that you're right, but I also want to emphasize, we are getting sidetracked here. This is not the issue.
Okay, that's a conversation for another time.
Yeah.
I was just trying to make sense of the 380. I thought that's why it was matching up to get them terminated, but that's fine.
well, and this is, I think this is material to my analysis, because I am under the belief that they automatically terminate and they have to re-register. I was not under the belief that an independent committee had to zero out to terminate. But I will get into the facts of the,
Yeah, let's go to 260033C in the matter of Phinia Atten.
Ms. Atten she's the sitting Rockdale County Chief Magistrate Judge. This was a commission-generated complaint, and it was a result of an audit that we did on Rockdale County, an ongoing audit. She agreed that she had 4 CCDR violations of 21-5-34C. She also agreed that she had 2 violations of 21-5-50A. Those are 2 PFDS violations. She agreed upon $750 in late fees, a $500 civil penalty, for a total penalty of $1,250.
All right, case number 26-0014C in the matter of Tawana Smith.
Ms. Smith, she's the sitting Rockdale County Commissioner for Post 1. This was also a commission-generated complaint based on an audit. She agreed that she had 5 violations of 21-5-34C, CCDR violations. She had 2 violations of 21-5-50A, those are PFDS violations. She had $875 in late fees, a $375 civil penalty, for a total penalty of $1,250.
And is your last one Janice Van Ness?
I have Roderick Gay,
Sorry.
position G.
Sorry. Yeah, case number 25-0103C in the matter of Roderick Gay.
This was a third-party complaint filed with our office. Mr. Gay is a sitting member of the College Park City Council. As a member of City Council, he has access to a community enhancement fund, which is public funds that he can use for different community initiatives. In this case, he used funds from that common fund in the amount of $3,262.65 on a drive to support legislation that appeared on the ballot in College Park. It was a senior citizen property tax exemption. So he had graphic work done, and the substance of the graphic work was vote House Bill, 554. There were banners that were put out, there were mailers that were sent out, promoting or advocating for the passage of this particular bill. That's classic ballot committee activity, requires registration after exceeding $500, requires 2 reports that need to be filed detailing your contributions and expenditures. In addition to that, there's a prohibition on public funding of a ballot committee, so there were violations tied to that. Aside from that, so the violations, there were 3 violations of 21-5-34A2. That's for failing to register as a ballot committee, and that's for failing to file the 2 disclosure reports. There was 1 violation of 21-5-30.2, and that's for expending public funds on a ballot committee. Aside from that, I just looked at his individual campaign, and he had 3 lates that were due for 3 late filed CCDRs. So 3 violations of 21-5-34C2A, and then 1 violation of 21-5-50A for failing to timely file his calendar year 2025 PFDS that was filed late. He agreed to refund $3,262.65 to the city of College Park. He agreed to pay late fees in the amount of $500 and a civil penalty in the amount of $1,500, so a total penalty to the commission of $2,000.
Okay. Case number 26-0012C in the matter of Janice Van Ness.
This, Ms. Van Ness was she's a sitting county commission chair in Rockdale County. This also came from our Rockdale County audit. She agreed that she had 5 CCDR violations of 21-5-34C. All but one of these were just things that she filed prior to our complaint, but just were filed outside of timelines. She also had 3 violations of 21-5-50A PFDS violations. She agreed upon payment of $1,000 in late fees, $125 in civil penalty, total penalty of $1,125.
Okay. Is that the last one for you?
Yes, sir.
Okay. When we vote on these, I'm not agreeing for the record that with respect to your investigation with, in the David Muzio case, that the House is better than the Senate or the Senate's better than the House.
For my investigation only.
It has nothing to do with him being appointed by the House.
Okay, thank you. All right, case number 25-0104C in the matter of Joshua Butler.
Yes, Mr. Butler ran recently in 2025 for mayor of the city of East Point. He was unsuccessful in a runoff election that was held in December. He filed his DOI on July 18th of 2025. This was a third-party complaint that we received in late November of last year. Essentially, Mr. Butler didn't file any of his CCDRs or his PFDS, didn't make any of his filings after doing the DOI. So he missed 6 CCDRs and he missed 1 PFDS. The total penalty imposed was $2,000, 7 late fees in the amount of $875, and then a civil penalty for $1,125.
Okay. Case number 26-0007 in the matter of Kenneth W. Harmon Jr.
Yes, and the next 9 cases, including this one, there's 10 total cases on this agenda. They all originate from an audit that we conducted of Jackson County. So the next 9 that I speak about are all from the audit that we completed. Mr. Harmon was an unsuccessful candidate for sheriff of Jackson County during a primary election held in May of 2024. He had 7 violations, which were all different CCDR violations. And the total penalty imposed was a $1,200 penalty, so $875 late filing fees for the 7 missed CCDRs, and then a $325 civil penalty. He was majority self-funded, he was cooperative, and he only had $700 in his bank account, so.
In his
Campaign bank account,
Okay.
yes. Yes, his campaign bank account, and he's now terminated, so.
Case number 26-0009C in the matter of Albert Andrew Andy Garrison Jr.
Judge Garrison is the sitting chief magistrate judge in Jackson County. He was successful during a general election held in May 2024 during their nonpartisan election. He had 3 different violations. Essentially, after that May election, he did not continue to file his CCDRs, so he missed 3 election year CCDRs, the September, October, and December, and then he subsequently filed his affidavit. So he's already paid his penalty in full, which was a $750 penalty, $375 for the 3 late filing fees, and a $375 civil penalty.
Case number 26-0010C in the matter of Candace Taylor Heaton.
Yes, Ms. Heaton is the Jackson County Tax Commissioner. She ran unopposed in the 2024 general election. She missed 5 CCDRs due to a misunderstanding with her affidavit and when that expired and when she needed to refile her $2,500 affidavit. So she missed 5 different CCDRs, with the penalty being a total of $750 for $625 in late filing fees and a $125 civil penalty.
Case number 26-0015C in the matter of Joshua Shepard.
Mr. Shepard ran for Jackson County Commission District 5 in a special election that was held in March of 2024. He was unsuccessful in that election. He did file the 15-day CCDR, and then he just stopped filing after he lost that special election. So we have 1 violation of failing to terminate, file that termination statement within 10 days of the dissolution of his campaign for a $250 penalty, so $125 late filing fee, and $125 civil penalty that he's already paid in full.
Case number 26-0016C in the matter of David Kenneth Whitfield.
Mr. Whitfield is the longtime coroner of Jackson County. His last election was in 2024. He's consistently run unopposed. This is another case where he had some confusion about the affidavit. So he missed 1 CCDR, and then he also didn't realize that he was supposed to file the personal financial disclosure, I guess, on a yearly basis, so he missed 2 of them. So that means he has 3 violations. He paid a $500 penalty, $375 for 3 late filing fees, and a $125 civil penalty.
Sorry. Case number 26-0016C in the matter of David Keith Whitfield.
That's,
Did I skip one?
yeah, that's the one we just talked about. That's the longtime coroner who was unopposed.
See, I didn't put my check mark. Someone
I
was
was like,
trying to talk to me. Case number 26-0027C in the matter of Madonna Swanson Hard.
Ward.
Ward?
Yes,
Oh,
Miss.
see, he's got me all this completely.
Just wrote you a note, like we're in high school.
Yeah, Miss Ward ran for Jackson County Board of Commission and for District 4 in the 2022 general election. She was unsuccessful. And then she just never terminated her campaign after she lost that election. So she had 1 violation for failing to timely file her final report and termination statement, and she paid her $250 penalty already.
Case number 26-0028C in the matter of Steve Witchery.
Mr. Witchery, he was another unsuccessful candidate for Jackson County Board of Commission District 3. There was a special election that was held in November of 2024 for this position, and this is another violation that he failed to terminate his campaign timely, and he already paid his $250 penalty.
Case number 26-0029C in the matter of Jonathan Ty Clack.
Mr. Clack was the successful candidate for Jackson County Board of Commission District 3 during the special election in 2024 held in November. He had 2 violations, another, I think, confusion about timing of affidavit filing. So he missed the December 31st, 2024 election year CCDR. And then he also didn't file his PFDS within 15 days of qualifying for that special election that year. And he had a $250 penalty for those 2 violations.
Case number 26-0030C in the matter of Chad Bingham.
Mr. Bingham was a successful candidate for Jackson County Board of Commission District 3 during the 2022 election cycle. He had 6 violations, 5 CCDRs, and 1 personal financial disclosure statement within 15 days of qualifying. This is another confusion about the affidavit, why he missed those filings. So he had an $875 penalty, so $750 for those 6 late filing fees and $125 civil penalty.
Case number 26-0036C in the matter of Daniel Perdue.
So this case and the next 5 cases, they're all, so every case left except the last one, they are all a third-party complaint that we received on all the Board of Commissioners for Houston County. They're all the same. Essentially, none of these commissioners realized they were supposed to be filing personal financial disclosure statements. So specifically, Mr. Perdue had 4 violations. He was successful during the 2022 election cycle, so he missed 4 personal financial disclosure statements, and he received an $800 penalty. So $500 late filing fee and a $300 civil penalty.
And you can just tell us how many violations there were on the
Okay.
other ones related, and then, what the total amount of the resolution was. So 26-0037C in the matter of Shane Gottwalls.
Mr. Gottwalls missed 4 different personal financial disclosure statements, and he received the same $800 penalty.
Case 26-0038C in the matter of Gail Robinson.
She missed 3 different personal financial disclosure statements, so she received a $625 penalty.
Case 26-0039C in the matter of Neil Tal Talton Jr.
Mr. Talton missed 4 personal financial disclosure statements and received an $800 penalty.
And case 26-0040C in the matter of Mark Bird.
He missed 3 personal financial disclosure statements and received an $800 penalty.
The last case is,
Mr.
Oh.
Chairman, can we stop there and vote on these? Because I'll need to recuse myself on the last agenda item, because I did have some communication about it with the agency.
okay. With respect then to all of the consent orders, A through X, other than, which one was yours? Mr. Cusack? Aye? All right. So with all of the ones A through X, except for I make a motion to approve. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right, that passes. And then with the last case, 26-0026C, in the matter of Joseph Cole.
Yes, Mr. Elrod, he is a part of the Jackson County
Oh,
audit.
Sorry, Elrod.
Yeah, he's part of the Jackson County audit. He's a successful candidate for Board of Commission in District 5 during a special election in 2024. Another misconception about the affidavit issue. So he had 5 different violations and all were missed CCDRs. And he received an $800 penalty, so $625 for the 5 late filing fees and $175 civil penalty.
What is this misconception about the affidavit that keeps
It seems that the Jackson County folks just didn't understand when the affidavit expired after their election, and so then they were under the belief that they did not need to continue filing CCDRs. Most of these filers were 0 reports, self-funded campaigns, or people who ran unopposed. So they just didn't think they needed to keep up with the CCDR filings or renew their affidavit when the new election cycle started.
I just have a question. In regards to the affidavit, with the new filing system with taking over, and this may be for Mr. Knittel of the implementation, when the local filers come back to filing with the commission, how will the affidavit be handled? Will they have the option when they register to opt into the affidavit, and then?
Shouldn't it be after we take this case up?
Oh, did we not vote? Oh, no.
It's okay.
Well, we're on the topic. So how's that going to functionally work? And then when the affidavit expires after their election cycle, will they get notice that the affidavit is going to expire and these situations won't be created anymore? Is that operationally how it's going to work, or?
So the first question's the easiest to answer. Yes, they'll be able to file the affidavit within the system.
Okay.
I think at the system, and they're still tinkering around with that portion of it because,
It's hard to implement, I would
yeah.
imagine.
But, as far as them getting notice when they've gone over, or are you asking if they get notice that they need to file a new one?
Yeah, because when the election cycle ends, the affidavit expires, they need to file a new one if they want to not have to file reports. So are they going to get notice that their affidavit has expired and that they need to file a new one?
I don't know that we've contemplated sending them notice, but obviously the affidavit itself does indicate that. But what we've been doing on some of these other filings that people have, pop-up's not the right word, but there's a little help, box that describes what that's for and things of that nature. That could be one way we handle it.
Okay.
I don't know if they're gonna get notice on that.
Or you could just be like me and just call up and ask someone, what in the world am I supposed to click on this one?
It's a confusing concept. I mean, just from
Yeah, they
speaking
will
from
get that.
the council members I've dealt with, they, like, how does this work? I'm like, well, it expires the day after your election. You need to file a new one or else you have to file that report. So it's a confusing concept. I understand why these people got messed up, but I was just curious how we're gonna implement that with the, now it's away from the locals coming back to us. So I was just curious.
So,
All right, with respect to case number 26-0026C in the matter of Joseph Cole Elrod, make a motion to approve the consent order. Do I have a second? Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right, so that will complete all of the consent orders. Item 5 on the agenda, we have 8 administrative dismissals. We generally don't have any discussion with regard to the administrative dismissals unless any commissioner has a question or asks Mr. Amati or the office to, I guess, withdraw the dismissal and put it back in place. Is there any discussion necessary with respect to the administrative dismissals? Mr. Amati, do you have anything that you need to add with respect to the administrative dismissals other than what was provided to us in the packet?
No, sir.
All right, we're gonna move on to, does anyone need to take a break? Are we good?
Fine.
You okay? We're gonna move to item 6 on the agenda. This is the report of the executive director, legislative update.
There was legislation, most of it died. No, look, in all seriousness, I think everyone has a realistic understanding going into a statewide election year that the dynamics at the Capitol are a little more complicated with people running for other offices. There were a lot of ideas thrown out, a lot of bills that passed one chamber, not the other. I think you'll see some of those come back next year, but there weren't any major changes that I think will impact day-to-day. It was mostly just cleanup ideas.
Okay.
Budget also went well for us, had a increase in funding from the General Assembly. With the rollout of SB 199 and the locals coming back to the state beginning 2027, they recognize there's gonna be a lot more work that goes directly to the commission that had been sort of filtered through the local filing officers in the cities and counties. So they funded an additional trainer and staff attorney to help with that sort of increase, and we're appreciative of that support.
Is this gonna be something where we're gonna have, dedicated counsel for locals and then dedicated counsel, on the state level?
I think that's definitely an option. I don't think it's required.
Oh, no, I wasn't asking if it was required. I was
Yeah.
just asking for, purposes, in the office, so that was easier.
I think the reality is the local cases, for the most part, tend to be simpler. And so that might be a good focus for a brand-new attorney coming in who's unfamiliar maybe with this area of law to ease into the practice. But then like everything else, I think we evaluate our resources against the issues we're dealing with and use them as best we can. So there may be times where, yeah, it's dedicated to local, and there may be a bigger investigation where we need more hands on deck, more legal minds involved. I think we just stay flexible and make sure we're doing the best we can with what we got.
Okay. Anything further, Mr. Amati, with respect to, this plan, I guess, that we implemented, going around the state, trying to put our training, in the different areas that we visit? I think there are other events that are going on in Savannah,
Right.
now and through the weekend. Tell us about that.
Yeah, so we're going to have staff stay when you all go back home. The Georgia Municipal Association, GMA, is having their annual conference down here in Savannah. Miss Easterwood and our team are going to have essentially a bank of laptops set up at GMA where we're going to be able to walk through in person as many local elected officials and show them, hey, by the time it's ready to, for you to file with us next year, we can go ahead and set up an account. We can get you prepared. We'll show you how to do it. And I think we're just going to try and go to as many locations as we can and be efficient in educating as many local officials as we can.
Are you gonna allow them to set up now? And if so, that won't trigger anything?
If they register for the 2027 cycle,
Okay. Okay.
Tell us about it. You might need to go to the microphone, though.
Or just yell.
So we're going to go ahead and do the registrations, and the way that the system is designed right now is that it's not going to generate the reports until after this year's reports are due, because they're still filing with those locals. And so once they file that 1020 report, the system will allow them to then renew. So if they're in an active cycle, they are going to register for that cycle. They just will not have those reports.
Will they also be able to file the affidavits for next year? Or is it just registering? Because
Well-
they register with the commission now.
Yeah, so it's just the registration. Now, if they have an affidavit on file, when they do the registration, there is a place that will recognize, do you have an affidavit currently on file? And if that's the case, then they'll check the box and it will recognize that.
Okay. Any other questions for Ms. Easterwood while she's up there? All right. Anything else, Mr. Amati, with regard to the report of the executive director?
no, sir.
Okay. We'll move to item 7 on the agenda, the report of the Attorney General's office. Ms. Young?
Hello. I have just one matter that I wanted to update y'all on. It was the matter of the Georgia Republican Assembly Inc. and PAC case. We took that to a hearing with OSA in May 13th. And it was a significant hearing. It was an all-day proceeding. Mr. Baywell was our witness on behalf of the commission and was on the stand for hours and hours and helped us identify and authenticate 94 trial exhibits. So we have a very robust record before Judge Capraro that is being considered by him. We also have some pretty extensive post-hearing briefing that we just submitted on the 15th. Judge Capraro will have 30 days following that submission in which we would expect him to enter a written order. So I would ask that y'all kind of be on your lookout for that. The commission will have a 30-day period to review that order once it comes in. So we will be expecting that around July 15th-ish. It could be, a little earlier than that, depending on when the judge gets around to writing that out. But be on your lookout for that. It'll be circulated as soon as we receive it. And the commission can either allow that order to stand by operation of law by doing nothing, or if there's anything about that order that poses a concern for the commission to address it, we'll need to act probably before the next quarterly meeting is scheduled, and may need to call a special meeting if anything happens that requires any attention. So, thank you.
Does staff do that now with respect to any decision that's rendered, where we wouldn't be able to get to it at the next quarterly meeting? Do y'all let me know, that that's out there, so that if anyone needs to address anything with respect to the decision, that we need to call a special meeting? Okay.
And that's
All right.
it. Thank
Anything
you.
else?
That's all I've got. Thanks.
Any questions for Ms. Young? All right, thank you very much. Do we have anyone that signed up for public comment? No? All right, we're number 9 on the agenda. I'm going to make a motion that we enter executive session to discuss personnel. Do I have a second? Got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? Okay, we'll be in executive session. I'm going to call us back to order with regard to our meeting today. I need to, first of all, get a vote. I'm going to make a motion that we leave executive session and return to public session. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Okay. So we're now back into to public session. We've concluded an executive session on personnel matters. We do have a few personnel updates. We heard we heard this morning that it was confirmed that Mr. Amati has received an appointment to the Superior Court of Fulton County. The only thing that I'm going to say about this, because I'm going to give you the opportunity to speak, is that I was part of hiring Mr. Amati. I think our goal from the time that he began was to put this commission in a much better place than it was when we started. And I think we've accomplished that. He's been a great executive secretary, and he's been an equally good friend. So, go ahead. I hope I didn't steal too much of your thunder.
No. Thank you, Mr. Chairman. Thank you, Jamie, because you can't fire him anymore. I did get the good news. The press release went out this morning. The governor's appointed me to the Superior Court bench in Fulton County. So I did serve sort of notice to the commission that I will be resigning from this post effective upon my swearing in, which, I don't know what that date is yet. It'll be a few weeks, but not terribly long. I just want to thank the people in this room, the people up here, the staff that have been with me the whole time. I was joking with Katie the other day that, the other night when we were at dinner, we were all there, and I said, that first year or two, we would all leave the office, and Morris, our chief of staff, would say, that first year or two, I had a migraine every day. And then by the second year, I was like, I only had a migraine like half the days we left this week. And then by year 3, we had accomplished what, Jamie, we had set out to do 8 years ago, which was take this agency from a place where it was constantly in the paper for the wrong reasons and have it be in the paper for the right reasons. Have it be an agency that wasn't a gotcha agency, that people trusted to help them when they needed help, but also trusted to do the right thing when people did something malicious or intentional. And I know every decision I have made in 8 years has not been perfect. You look back and say, I wish I could do that different, but on the whole, I'm proud of the work we've done here. I think we've done a good job. I think we've accomplished what we meant to. And, I couldn't have done that without the support of, well, not you so much, but the rest of you, and Joe, who was with me from the beginning as well. So thank y'all for having my back and letting us do the work we do here.
Does anyone have any other comments, anything of that nature?
Here, David, you can. Take it with you. I don't know whose it is, but.
Well, I think what we need to do at this point then, I know we haven't received any type of letter, in writing at this point, but I think to proceed in the fashion that we feel like we want to go, I'm going to make a motion to accept Mr. Amati's resignation pending his swearing in as a judge on the Superior Court of Fulton County. So I'll make that motion. Do I have a second? I got a motion and a second. I thought I heard someone, so I'm sorry. I got a motion and a second. Is there any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right. That part's done. So we had to do this. I won't say that it was quickly. I think that we had anticipated that this could certainly happen. So we met in executive session. We discussed the matter, and I think that we have come to a conclusion. And I don't know, does anyone have anything that they want to say before we proceed any further on this issue? All right, I think that everyone is comfortable at this point, so I'm going to make a motion for Steve Knittel to be appointed Executive Secretary of the State Ethics Commission upon David Amati swearing in as a judge on the Fulton County Superior Court, considering the resignation was connected to that. My motion also includes that a salary set for Mr. Knittel will be $185,000. I've got a motion. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Welcome, Mr. Knittel. All right. We've got one further motion that I'm going to make at this point. I'm going to move that Ms. Katie Easterwood be hired as Deputy Director of the State Ethics Commission. Do I have a second?
Second.
I got a motion and a second. Is there any discussion? Hearing none, I will call the question. All in favor, say aye. Aye. Any opposed?
No, I'm okay.
Ms. Easterwood, welcome to the new position. All right. That will take care of the update on the personnel. We'll now move to number 10 on the agenda, which is adjournment. I got a motion to adjourn.
Second, motion, second.
Got a motion and a second. Any discussion? Hearing none, call the question. All in favor say aye.
Aye.
Aye. Anyone opposed? All right, we'll see y'all next time.